All right, everybody. Sorry about the delay there. It took a minute to get everything on. So, as I'm sure all of you know, the exciting news that's happened is that PG&E has funded the trust, which is obviously great in that we now know that the money is there. The problem is the stock is not where we need it to be. So, if it gets up to about 14, then that gets us the 6.75. Obviously, we hope it goes much higher, but it's not there yet. So that's where we are right now. And in terms of the other news, one of the things that happened when PG&E funded early, as you remember, they were supposed to fund on or before August 29th, and we didn't find out until 2 days ago that they were going to fund yesterday. They sent us an email about 9 o'clock at night saying that they were going to fund tomorrow. This is on Tuesday. Wednesday morning, they funded. So it caught the trustee and the claims administrator a bit by surprise, and they do not have the portal up and running. If you look at it, it says that it's accepting information, but the questionnaire, which is what they need to begin processing claims, is not going to be available until the 29th. So in terms of the overall timing, the fact that they funded now doesn't really make a difference. We're still looking at October payments. That's when right now things are scheduled. That could change a little bit depending upon a motion that has been filed and will be heard next week by some of the pro pers, but we don't really think that that's going to go anywhere. So I still think we're looking at October in terms of funding, but now the good thing about this is there's no longer any question about will they fund, won't they fund. It's done. Now it's just a question of we need that stock to keep going up. Since they funded, the trust has about 400 million more in stock than it had when they did. All indications are the stock is going to keep going up. Certainly there's no guarantee, but that's what we're hoping for. So let me start by going through the questions that people sent in. There's only a handful of them, and then we can take your questions. Okay, number one, an article in the New York Times on July 2nd stated that PG&E would make payments into the trust fund for victims in 2020, 2021, and 2022. How will this affect claim payouts to victims? That is, will full payment on allowed claims be delayed until those years? And additionally, if so, any idea of the percentage of the claim award that would be paid during these various payout times? All right, so that's a good question. Let me start by explaining the payments that are going to be made. So the first payment has been made. That was the 5.4 billion in cash, and because they advanced 15 million about 2 months ago to get the whole claims resolution process started, that was technically 5,385,000,000. But that 5.4 billion has been made. And then in terms of cash, they are going to make two payments, 750 million in January of 2021, and then the final 600 million in January of 2022. So that's the payout schedule in terms of cash. The stock has already been paid. So the only thing that's going to impact that is when the trustee, in consultation with Houlihan Lokey, which is the name of the investment banking firm that the trustee has retained to assist him, decides to sell. We are hoping that the sales are going to take place starting early next year. The reason for that is that if PG&E is able to post the increased net earnings that they anticipate they will be next year, then that means the stock will go up substantially. So right now it's in the mid fours. I think it's about 4.45 billion. If it gets up to around 14 per share, then it will become the 6.75 billion. And if it keeps going, and the hope is it'll get up to 16, 17, 18, then it'll be worth substantially more. And again, that obviously is the goal. So the hope is that the trustee will be able to hold on to that stock until early next year, when it's anticipated that it will go up significantly and it will be worth a lot more. Obviously, again, that is conjecture. We don't know that for sure, but that's what we're hoping. So in terms of the percentage of claim awards that are paid out, as we've talked about, that is not going to be dependent upon the cash payments, because everyone is doing theirs at different times. We have some cases that are ready to submit now, but we have a number of cases that still need things, whether it's personal property, whether it's information from clients, whether it's expert reports, all of those things. And as we get them, we submit them. And the same is true for everyone else. So what is going to happen is, as the trustee evaluates the claims, he likely will pay out 75% of the total amount. So again, if your claim was determined to be worth $1 million, then he allows 1,000 in the initial payment. He'll hold back that 25% until he is certain that everyone will be able to receive all of their allowed claim amount, so 100 cents on the dollar. If it turns out that it's not going to be enough and we can only pay 90 or 95 cents on the dollar, then that will be applied pro rata, so everyone will get the same amount of the reduction. It won't be that the people that went first get 100 cents on the dollar and the people that go last get 90 cents. Everyone would get 95 cents on the dollar. So that's the way that's going to be done. In terms of when they will know that and when they'll make that final payment, we won't know until all the claims are in. Right now, the deadline for submitting all claims is December 31st of this year. I can tell you there is no way that is going to stick. They just won't do it, because I can guarantee you there'll be 30% of people, whether it's pro pers, whether it's people whose attorneys aren't, being as diligent as they should, whatever it is, that is not going to happen. So my guess is they'll delay that. Could be 90 days, could be 180 days, 3 months, 6 months. We won't know until they do it. But my guess is it'll be sometime mid 2021. Then it'll take an additional 6 to 12 months to get everything resolved. So the goal is that everything is done within 18 months of now. The initial payments will start as soon as October, but the final payment, that 25% or so that's withheld, the percentage of that will be determined once all of the claims have been adjudicated, and then they'll either release the full 25%, or if it has to be less, they'll do it on a pro rata basis. So that's the answer to that question. Okay, the second question, let me check here to make sure. All right, it says my Wi-Fi connection is weak. Let me try a different form. Hang on one second here. Okay. How about now? Is the connection any better?
Yeah, better, Jerry.
Okay, good. Okay, so the next question that was asked was it says, must the CRP be finalized now that the trust has funded? Yes, the claims resolution procedures have to be finalized. And again, the questionnaire should be provided on July 29th. And that's when they'll start accepting submissions. Next question. I haven't decided to rebuild. Is there a time limit when I need to inform you of my decision? Also, will it delay receiving my settlement? No, there is no time limit. other than there is going to be a deadline for submitting claims. Right now, it's December 31st of this year. There's no rush at all. And remember, it doesn't have to be a declaration stating that, you absolutely categorically will rebuild. If you'd like to rebuild, if you get sufficient money, that's acceptable. So obviously, if you've decided you're not going to rebuild, you need to let them know that. But if you would like to rebuild, if you receive enough money from the trust, then that's certainly something that you can put in. Next question. What happens if a fire victim dies prior to full payout of the claim award? Do the funds get tied up in the victim's estate with all of the legal complications that go along? So that's a good question. The answer to the first part of that question is that it depends upon how the victim died. If the victim had, for example, some type of breathing issue or had a heart attack or something like that that was related to the fire, then it becomes a wrongful death and they can still recover all of the damages that are associated with their claim. On the other hand, if you have someone who suffers a loss and then dies of some unrelated cause, again, whether it's natural causes, vehicle accident, something like that, then the heirs are allowed to recover the economic damages, so real property loss, personal property loss, anything like that, but not the non-economic damages. Unfortunately, under California law, non-economic damages die with the individual. In terms of how that is passed on, it depends. There's no delay in the case because if they had a will, then whoever is designated in the will becomes the heir and goes forward with the suit. If not, then there's a section of the probate code which delineates who the next individual is and they carry forward with the suit. But in terms of what happens with the money once it's recovered, that can depend. It depends on the size. Certain amounts are low enough that they don't have to be probated. If you have a trust, then obviously that doesn't have to go through probate, but there are times when awards will need to be probated. So it really is a case-by-case basis. And then the last question in the questions that we received was, since I am represented by an attorney, will I be able to access the portal? And if so, how? The answer to that question is you can. And if you want to access it, let us know and we can walk you through how to do it. There's not a way that I can just kind of let you know how to do it now, but if you want to do it, then the person to reach out to is Erica. So it's just Erica, ERIKA at slffirm.com, and she can walk you through it. Okay, that is those are all the questions that we had. So Chewy, if you want to take us through the other questions that have come in, we can start responding.
Sure. First question I have is, my neighbor bought a house elsewhere and is selling her lot that abuts mine. If she sells before settlement, will that damage her claim? And second part of the question is, I am thinking of taking a loan to purchase it. Would that have a detrimental financial effect on my claim?
Okay, in answer to the first question, will it damage the neighbor's claim? Yes, if she has sold her property or if she intends to sell her property, then she is limited to recovering diminution in fair market value. The only way you can recover cost of cure, which is a higher amount in 99 times out of 100, is if you, number one, intend to make the repairs, and two, have the ability to do so. So if she sells her property, then she obviously would not have the ability to make the repairs because it would belong to someone else. However, if she's going to sell it anyway, then she can't truthfully say she's going to make the repairs, so I don't think it would affect her. To answer the second question, would it affect your case if you bought the property? No, it would not. It would have no effect whatsoever.
Okay, and one question just came in about, let's see. Is there an option to keep a small amount in stock?
No, that's a good question. That was something we went back and forth on. The trustee ultimately decided that there really wasn't any fair way to do it. So the way they're going to do it is the trust is going to hold the stock and they're going to sell it as needed to pay the awards.
Thank you, Jerry. And then I was just emailed a question about something you mentioned when we started the meeting. It says, why do we have to wait until October? The trustee is making millions. Why can't they pay us now?
That's a good question. The reason is that they have to get the process set up and get the claims run through. And again, under the terms of the RSA, and in terms of what we were all expecting, we weren't expecting to get paid until August 29th. So while the trustee has been working on this, excuse me, they haven't had enough time to set up the program. And remember, unfortunately, there really is no blueprint. This is something that we have literally created from scratch. Because of that, it takes a lot of time. The trustee did roll out a sample program last week, and while I certainly commend their efforts, unfortunately there were issues with it, and a number of us, not just me, but other people that are on the Trust Oversight Committee and other people that we consult with, all felt that it needed some significant work. So they're making those changes, and it won't be ready to go until July 29th. Once it's ready, then we'll put it in, and it will take, I think, 30 to 60 days to get a good number of cases worked up and ready. Once those are worked up and ready, then they can start making the distributions, which will happen in about 30 days. That's why October is what everyone's thinking. Obviously, if it's sooner, that would be great. I know everyone needs to get reimbursed as quickly as possible, but October is what the trustee told us, and I think realistically, that's what we're looking
at. Thank you, Jerry. I don't have any more questions submitted here on the chat.
Okay.
So we
Well,
can
let's open
it up.
Who's got questions on the board?
I have a question.
Sure.
You said earlier, Gerald, that about 75% of the total award would be paid out initially.
Right.
What I have received insurance payment, not a lot. Will 100% of the prior insurance payment be deducted from the 75%, or only 75% of the prior insurance payment be deducted from the first award?
Right. No, good question. So the way that it works is that they're going to come up with a final number. So let's just, for the sake of argument, we'll use round numbers. Let's say that your total losses for your home were $1 million and you had $600,000 in insurance. So you would take the million, deduct the 600,000, and 400,000 would be the amount of your final claim. So you've agreed to that. Everyone thinks it's fair. That's the number that you should receive. Of that 400,000, the trustee is then going to take 75%, so 300,000, and pay that to you. You'll receive that amount, and then that last 100,000 is going to be held in the trust until the trustee has determined that he can pay the full amount. Once he does that, he'll release the funds. If it turns out that he's not going to be able to do it and he can only pay 95%, then he'll release 95% of that amount. And that's how it'll work.
Jerry, I have a question here. Can you explain the claims process in terms of what can be claimed and what proof supporting materials are needed for each of the claim elements?
Sure. So the type of proof varies according to what you have and what you're claiming. Obviously, the more unique an item, the more proof you're going to need. I'm sure everybody saw that there was a gentleman who claimed that he had a $260 million emerald. Obviously, if he wants to get paid on that, he's going to have to provide a lot of proof, because that's not the kind of thing that most people have. You know, taking a less extreme example, if you had, you know, something that was very unusual, if you had an original oil painting of, you know, someone who was a famous artist, if you had an antique from the, you know, 17th century France, I mean, something like that. Those are the kind of things where they're going to require a lot of proof because they're very unusual and they're very expensive. When you're talking about regular, ordinary household items that all of us have, you're really not going to need any proof other than your own statement. So if you go through and you create a personal property list and you're saying, in the bedroom, I had a bed, I had a dresser, I had clothes, I had a chair, I had a TV, all of the things that we would expect, they're not going to bat an eye. It's when you have anything unusual that they're going to want proof. And sometimes you're not going to have it. I mean, you know, people have, for example, I've had a lot of clients who had, you know, baseball card collections, coin collections, really interesting things that are unusual. And unfortunately, everything related to it was burned in the fire. When that happens, it's understandable. Usually you can provide a statement from someone who'd seen it, but sometimes, you know, you can't even do that. So what I always tell people is put yourself in the position of the trustee. You are sympathetic to the victims and you want to pay them. At the same time, you recognize that you do have a limited fund, and if you pay a claim that's not meritorious, it means you're taking money away that could go to a meritorious claim. So if you're claiming something ordinary, you're probably not going to need much proof. If you're claiming something that's extraordinary, then please provide everything you can. And again, the best thing to do is to look at phones, social media feeds, anything like that, and not just of you, because if you're like me, you know, you don't use Facebook, you don't use those kind of things. But a lot of people, particularly younger people, do, and they're always taking pictures. So, you know, you go on my daughter's Facebook, or they don't use Facebook, they use Snapchat and all these weird things. But when they do that, a lot of times, and they'll take pictures, there'll be things in the background that you can look at and you can see. So what I tell all clients is, please look at friends and family's social media feeds. Ask them to look through their phone. Do they have pictures that were taken at your house, whether it's of you, whether it's of somebody else? And a lot of times you can get helpful things there. In terms of if you're a renter and you're claiming that you live somewhere, if you have a rental agreement, that'll do. If you can show a driver's license showing that you live there, anything like that is fine. In instances where someone is maybe renting a room and it's recent, so they haven't changed their driver's license, if you can get a declaration from someone who lived there and who has proof that they lived there stating that you were in fact renting a room there, that would suffice. So anytime you have questions, ask any of us, me, Erica, any of the attorneys or paralegals who are on the team, and they can kind of walk you through it. What's next, Chewy?
Give me 1 second. I'm scrolling through the chat messages. I got quite a few right here.
Okay.
Okay, it says, related to this, will the trustee want to get our full insurance claim as a reference so they know what you already received payment for?
Yes. Part of this whole process is that the subrogating insurers are working with Brown Greer, who's gathering all the information, and they're transferring the insurance files over. And that way Brown Greer can just go through and deduct the amounts that are relevant for each of the claims. So if you claim personal property, they'll deduct that amount. If you don't claim personal property, they won't do it that way.
Thanks, Terry. I'm looking here at my emails also. I believe I have something that just came in.
Sure.
Okay, it says, with the payments being spread out over multiple payments, at what point does Singleton take their percentage? And 2, when will we find out what our total claim amount will be submitted?
Okay. So let me answer those questions in reverse. In terms of the total claim amount, there is not a final amount that's being asked for. It's just a bunch of different categories. They've asked us not to submit any amounts for emotional distress. We simply list the symptoms and the experiences that everyone went through, and then they'll put that in. So before we submit it, if you'd like to see what the total is for things like the arborist report, the construction, anything like that, we can give that to you, but there won't be an official amount, because otherwise everybody would ask for very large amounts, and it would create some issues with them. What they're asking us to do is just go through, fill everything out, and then for the emotional distress part, just put in what people experienced. Then once they see that, then they can come up with a number, give it back, and say, here's what the offer is. If that works, great. If it doesn't, then we go to mediation. So that's the amount of the claim. In terms of the other part of the question, when do we get paid? It's when you receive the money. So if, for example, they're paying 75%, then we would get paid out of that amount. So to use the prior example, if the payment was $300,000, then 1/3 of that would be $100,000. We would get paid then. If additional money comes, if they pay the full 25%, then we would get 1/3 out of that. If they pay less than that, then we would get an amount out of that lesser amount. But it's not a situation where, you know, we get the full amount of our fee up front, regardless of whether or not you get paid. We only get money as you get money. And when the money comes into you, then we get paid the third that is our fee.
Thanks, Jerry. Can the trustee award an amount conditional upon further proof being submitted by a particular claimant?
You know, I don't think they would do that. I think what they would do is just say, we need proof of X. If you can provide it, then we can pay you an additional amount. I think that's the way they would do it. I don't think they would say, you know, we're going to award it, but provide this. I think it would be more like the claims administrator would give us a call and say, look, you know, personal property, you've claimed this item. We need this piece of verification. If you can get that to us, then we'll be able to increase the value, something like that.
Thank you. I don't have any more emails or messages in chat.
One question,
Sure.
Gerald. Do ALE payments from the insurance firm impact in any way the payout from the trustee?
Only if you claim ALE. So in other words, if you have, let's say that the amount you've paid in alternate living expenses is $100,000, and you received $75,000 from your insurance company for ALE, then the amount of your claim would be $25,000. But if, for example, you are completely satisfied with the ALE you received and you don't have any amount over and above what you've been paid, then we would not make a claim for ALE, so it would not be factored in.
Okay, great. Got it. Thank you.
All right, who else has a question?
Hey, Jerry, so if we get 75%, let's say we get it's $1 million and we get 75% of that, that's $750K. Does the legal fees reduce that $750K by 33%?
Yeah. So the way that we get paid is it's from the amount you actually recover. So it's not the award, it's what you recover. So we would only get 1/3 of the amount you receive, not the total award.
So let's just do a little math.
Sure.
The claim is $1 million. We get $750,000, of which you guys get 33%, or 1/3 of that, which is approximately $250,000.
Right.
So the net payout to us would be somewhere around $500,000 on $1 million, the first tranche of $1 million claim.
Exactly. And obviously the hope is that you'd get the next 25% so that you would be made whole.
And then what does ALE mean?
ALE is alternate living expenses.
Yeah.
And so when you lose your home, obviously you have to rent a new place or buy a new place. That's what ALE is.
So we have a claim for the home, we have a claim for the contents, and if we had a business, we'd have a claim for the business. They calculate the pain and suffering, and so it would be a combination of those mix of things in the final claim, in the final payout.
Well, plus attorney fees. They have to pay your attorney fees on the economic damages. So that would have to be added in. And then you could have ALE and you could have other things as well. Sometimes people have lost wages, any kind of injury, anything like that.
So I want to be crystal clear because I think I may be confused. Are your fees, the fees we pay to Singleton, come directly out of our claim, or is PG&E paying some additional amount for those?
Right. No, that's a good question. They come directly out of the claim. What PG&E does is pay money into the claim for those fees. So the way that it works is whatever your economic damages are, they have to pay the attorney fees on that amount, and that gets added into the claim.
Oh, okay. So if our claim in itself is $1 million, then PG&E will pay out $1.3 million or whatever, $1.33 million.
Right.
We'll still get 75% of our total claim, which is $1 million, and then you guys get the incremental amount PG&E puts in to balance out the claim, right?
No, because the $1 million would be for everything.
Yeah.
So the $1 million would be not just for your economic damages, but also for your non-economic damages.
Yeah.
So
yeah.
I think the better way to do it would be to say, let's say your economic damages are $1 million. So on top of that, you put the attorney fees.
Yeah.
Then on top of that, you put the costs of suit, whatever those are. So let's say that the attorney fees and costs of suit together add up to $400,000. So you put that on top. Then let's say on top of that, you got, $300,000 for non-economic damages.
Yeah.
Now the total amount is 1.7.
Yeah.
And then of that, we would get 1/3, you would get 2/3.
Gotcha. But let's use contents as an example. Let's say my contents is $300K. My insurance company paid $30K. That's $270. Then the claim would be that $270 plus the legal fees on top of that.
Right. Plus your non-economic.
Okay, great. I understand. Thank you.
Yeah. Sure.
Yeah. Good clarification.
Okay. Who's next?
Jerry, I have a message here in the chat. It says, if we didn't rebuild and bought a different home instead, and the insurance company didn't pay full estimated rebuild cost, will the trustee make up the difference? If so, what evidence do you have to provide?
I need to make sure I understood that correctly. So if the question is, if you bought a new home, but the insurance company did not pay the, I'm having trouble following that, and here's why. The problem is, and whoever asked that question, please kind of correct me. So here's what I need to know. If you bought a new home, but you still intend to rebuild, then you're absolutely entitled to recover the cost to rebuild your destroyed home. However, if you bought a new home and you're not intended to rebuild, then you're limited to diminution of value. So that's why I'm having trouble answering the question, because the answer of whether or not the trustee would have to pay is, it depends. If you intend to rebuild, then the measure of damages would be the cost of cure. If you don't intend to rebuild, then it's diminution in value. So it's the value of the property the day before versus the value of the property the day after. You take that amount, you subtract the amount insurance paid, and the balance is what your claim is.
Right. Yeah, there was clarification. It says,
Okay,
yes,
good.
I still intend to rebuild.
Oh, okay. Then yeah. Yeah, absolutely. A lot of people will buy homes. They'll take their insurance money, they'll buy it, and then they'll buy a new home, and then they can use that home as a rental property when they rebuild. So absolutely, the fact that you've bought a new home doesn't disqualify you from getting cost of rebuild as long as you still own the property and you intend to rebuild.
Thank you. One more question here is what is the cost of the suit or the cost of the lawsuit?
Right. So we've talked about that before. There are two types of costs. There are joint costs, and then there are individual costs. And the joint costs are the costs that are applicable to everyone. So those would be the costs for proving up liability, deposition costs, filing fees, court reporter fees, all of those things. And typically that comes out to less than 1% of each individual because it's prorated. Now, it varies from case to case. In this particular case, on one end, you have the Tubbs fire. As everyone knows, CAL FIRE's report was wrong and they did not find PG&E responsible. So we did spend a lot of money proving up Tubbs. We got about 3 weeks short of trial before they finally admitted it and settled those cases. So while it's going to be less than 1%, it's going to be a lot more than something like CAMP. In CAMP, the joint costs are, very negligible. We did hire an expert. We did have one site inspection, but PG&E declared bankruptcy very quickly thereafter, and they pretty much admitted liability. So there wasn't a lot of work that was done on the joint liability costs in CAMP, which is where most of the joint costs are. So, CAMP is going to be like 0.1 of 1% or 0.10 of 1%. It's going to be very low. Whereas I think Tubbs is going to be higher. We have about 1,000 Tubbs clients, so it's going to be spread out among a lot of people. But we certainly spent several $100,000 trying to prove up Tubbs, so that is going to be larger. So that's the overall joint costs, and we divide that amongst everybody who we represent in a particular fire. Again, it comes out to be, in most cases, less than 1%, sometimes substantially less. The other costs are your individual costs, and these vary completely according to the type of case you had. If you were a renter, for example, and you didn't have any personal property that we had to get an appraiser for, then you're not going to have any individual costs because it's just making a personal property list and submitting it. On the other hand, if you're a homeowner and you needed a structure estimate, you needed an erosion, you needed an arborist, all of those costs are for your individual case, so they're only applied to you individually. Now, those reports are not particularly expensive because we order so many of them. We have deals with the experts, so they reduce them dramatically. But typically they range about $2,000 each. So, if you have all three, you're probably looking at somewhere between $5,000 and $6,000. If you have a very large property or a very complicated workup, it can be more than that. So it does kind of depend. And again, the higher end properties tend to have more expensive expert reports because they're more complex and they're larger. But typically it's less than 10,000. In a large case, it would be 20, 30,000, something like that.
Excuse me, you said something about an arborist report. I lost 23 trees. They're already gone. So I still have to have an arborist?
Well, the reason that you would need an arborist is because we need to value the trees. So
the people that took the trees out, he was an arborist. So it's already been done. So I have to do it again?
Well, it depends. Did he provide an estimate as to the value of each tree?
Not to the value, but he has the size and the type of trees.
Right. So what we need, and he can do it if you're more comfortable having this individual.
No, I just thought it was already
Okay.
done. So how do you value a tree that's not there and I have no photos? So,
Well, they just, what they do, and this is why the reports are so much cheaper now than they used to be, is satellite imagery is incredible. They can look at it and they can tell exactly what type of tree it was and the size it was based upon overhead satellite imagery. So they'll look at that and they'll say, okay, let's say you had 23 oak trees. That's going to be a lot more than, for example, 23 pine trees. Redwood trees are also very valuable. So they look at the type of tree, they look at the size, they look at the age, and they look at the contribution to the property. If you have trees that are, for example, shielding your home from the road and are therefore not only providing aesthetic value, but also are very functional in that they provide privacy, noise reduction, those kind of things, that's more valuable than if you had, for example, a strand of trees that is out on a remote area of your property. They look at all those factors and they come up with an amount. I can't tell you, Chewy just texted me that we have received an arborist report for your property. So if you'd like, please just email.
For mine?
Yes. And
Oh,
we'll email
okay.
it. Yeah, we'll email it over to you. You can take a look, let us know, make sure you're
Okay.
comfortable with it, and then we can
Okay.
submit it.
Perfect. Thank you.
Sure. All right, Chewy, do we have any other questions?
I have a
Jerry-
question.
Sure, go ahead.
Yeah, it's a simple question. Can we download the claim forms off your website? Is there a standard form? Or
No,
we
the
present-
questionnaire that they're going to ask for has not been finalized yet. So unfortunately, we don't have access to it.
Hey, Jerry, both me and my partner, she lost her home and been very active in the claim. She lost her business. There's been a lot of interaction with Singleton. I was renting, lost all my contents, house burnt down, but I had, I sent in my content list. There's been some interaction and they said they have everything they need. I assume I'm last in line, right? Because I didn't lose my home. Will someone connect with me, like Erica, to finalize it? Because the last conversation I had, they said, hey, we have everything, but it was a little while ago. How do you think that'll play out?
Well, if we have everything and we've completed the narrative, then typically we would just submit it once it opens up. So if they open up July 29th, then we can just submit it. If they need more information, then they'll reach out. But our general policy is once we have everything, we submit, unless a client tells us, I want to review it. And you obviously, everyone has the right to do that if they want to. So if we have a client who wants to do that, we just make a note in their file, and before it's submitted, we send it to them. Once we get their okay, then we send it out.
Should I expect someone to just say, hey, we're totally cool, we're ready to file, or are they just going to just do it?
Generally, if we have all the information, we'll just do it unless you've told us you want to review it. Because what we want to do is get everything done as quickly as possible. So once we've got it, we will submit it unless you tell us you want to review it.
Should I just send a note to Erica saying, hey, are we totally cool? Or
yeah, if that's the best person, because Erica is in charge of that aspect. She oversees the team that works on that. So she would be the one to give final approval to submit. So if you want to just send her a note, that'd be perfect.
Okay, and so for me, the claim is contents and then pain and suffering.
Right.
Pain and suffering, you're saying they'll calculate later. That's fine. That's totally on the contents. They'll just submit it and figure it out, right?
Right. Yeah.
Okay, great. Thank you.
Sure.
Jerry, I do have an email relating to some more clarification on the attorney fees portion of the claims.
Okay.
It says that you previously stated that the percentage your firm took would be added to the payout from PG&E, not deducted from the actual payout. Is that not correct?
Yeah, the way that it works is the economic damages are calculated, then our fees are put on top of that. Then on top of that is the non-economic damages. And the amount we receive is a third of the total because, we receive fees on both. It's just that PG&E, in this case, the trust, has to pay a reasonable amount for the attorney fees on economic damages. So it gets added in, is how it works.
Hey Jerry, so my partner had a house burned down. They're just finishing the rebuild. It was about 1.1 million to rebuild. but then the loss that worked out with you guys was higher than that because there was a community, there was a lot of shared assets. So the claim is going to be for the larger amount minus what the insurance company paid, right?
Correct.
Okay, great. Thank you.
Yeah, and remember, a lot of times people don't build the same house. So what our experts look at is what it would cost to rebuild exactly what you had. And if you save money by, you know, doing certain things, that's fine, but that doesn't mean that they get the benefit of that. They are required to put you back in the circumstances you were in prior to it.
So the net of the claim is the difference between what you guys calculated, which you guys gave back to us, and then what the insurance companies paid out.
Right.
Okay, thank you.
Hello, Jerry.
Yeah,
I have a question about personal property.
sure.
So they paid me 75%, and I contacted them, and they said that the claim, I can no longer access that next 25%.
Okay.
Can I then get that 25% within the fire claim?
Yes, but we need a letter from them explaining why that is. So
Oh, good.
did they
Okay.
did they send you a letter saying, you know, under the terms of the contract, the time is expired and therefore you can't recover it or something like that?
Yes. Yeah, they're going to
Okay.
send that to me. Okay,
Good.
good. Perfect.
Yeah, as long as we get that, because again, what the trustee wants to do is make sure that you do everything reasonable to recover it. But if you can't recover it because you don't have that option, then obviously it wouldn't be reasonable to expect you to do so.
Okay, good. Perfect.
Um,
Right.
Jer-
Well, thank you.
Jerry, going back to a prior issue.
Sure.
You had mentioned about antiques, valuable things like that. We had some very valuable antique furniture and paintings purchased on the East Coast about 40 years ago, which appreciated dramatically since then. But all of the records are gone. In all
Yeah.
probability, would the trustee simply say, no way, because I have no way to prove anything on those?
No, I don't think so. Now, that is going to be more challenging than most. And so we may have to get creative, but we have to come up with anything we can to verify what it was that you had. So I understand all the records are gone. Hopefully there's some photos, but if there aren't, then what we would need to do is get the declarations of people who could say that they saw them and provide general descriptions. That's probably the best we're going to be able to do.
Okay, thank you.
Jerry, I have a
Yeah.
question.
Sure.
So, I mean, I hate to keep bringing up something that everybody else has brought up, but I did a little paperwork, and so I'm confused. So
Sure.
I want to use a very simple example, like the claim that you put in for a fire victim is $1 million. So on top of that, I'm going to keep this really simple, but
Sure.
on top of that are the attorney fees, which are $333.
Right.
$333,000.
Correct.
And then, so let's just look at those two items.
Mhm.
So if you said that they're going to come back with an offer, and let's say their offer is the $1,333,000, and we're only going to get 75% of that. But what I heard you say is that if we accept that offer of $1,333,000, that then your attorney fees of 33% are taken off at the top.
No.
Is that correct?
No. The way that it would work is this. There's a couple of other things. The non-economic damages would have to be added on there as well. So
I know.
Yeah.
But what I want to, so we'll do a total claim. We'll do $1 million for the claim, $333,000 for attorney fees. The
Yeah.
legal costs $1,000. Anyway, non-economic damages. We have a total. Let's say we have a total claim of $1,448,000.
why you're going to have more than they're definitely going to pay more than that for non-economic. It's probably going to be 1.6, 1.7, something like that.
So anyway, whatever it is, but so I guess what I want to understand,
Mhm.
whatever the offer is, you're going to take 33% of the offer as
No,
attorney fees. Is that correct?
no, no, no. We're only gonna receive 33% of what you actually receive. So to
Okay, well,
use,
that's okay.
yeah. So it's not like, for example, you're going to be paying, you're going to be receiving 75% of the total amount, and we're going to be receiving 33% of the total amount, because that would, severely shortchange you, obviously. It's, we receive a
Well,
third
it
of
would
what
be
you
like
receive.
getting, okay,
Yeah.
okay, okay. So like when you present us with an offer, is it going to include the attorney fees?
Yeah. So what'll happen is this: and again, let's just say that they made an offer of 1.5 million. What we would say is, okay, if it's 1.5 million, then here's the fees, here's the costs. So you would net, 980,000. Let's say there's 20,000 in costs and 500,000 in fees. You would net 980,000. Now, the problem here is this 75%. So what we would do is we would say, okay, you would net this amount right now, and then whatever 75% is, and then the rest of it, if it's paid out, would mean your total amount is going to be X. So what we'll do is,
So I know
go ahead.
I'm not concerned about the 75%,
Oh,
but
okay.
you made a statement that when the offer comes in,
Mhm.
that the attorney fees are 33%. And the way I heard it is that I heard it was 33% of the offer, which if that were true, you'd be getting attorney fees on top of attorney fees.
Right.
So,
No, that's not
because
the
the
case.
attorney fees
Right. No, no,
so
there's no fees on fees. It's just whatever. And remember, there's a couple of different things. There's our demand, which is the economic damages plus attorney fees plus non-economic. And then there's what their offer is, which is just one number. So whatever that number is, they're going to give it to us, and the attorney fees would be a third of that amount.
no, see, that doesn't work for me because so again, again, then that's telling me that if it's a third of that amount includes our economic loss, our non-economic loss, and the attorney fees that you added on top of it. So what I think what it is probably we're going to get an offer and it is going to include your attorney fees, but your
Right.
attorney fees are only based on what our economic and non-economic losses. I mean, it's only based on our economic losses because that's what you added on to our claim,
Right.
right?
The attorney fees that the trust pays are based on the economic damages. The attorney
And
fees that,
that's what you're going to subtract from the offer or what they offer us. In other words, if yeah. So if our claim was $1 million and the attorney fees are 333,000, they offer us 333,000. You're not going to take 15% of that. You're just going to take the 333,000, which was 15% of our claim.
no, it's again, the way that it works is they pay a portion of it and it goes into the overall award. The way we get paid is based on the overall award. So again, if the overall award's $100, we get paid $33.33. If the overall award is, whatever that is, that's how we get paid. The confusion, I think, is coming from how it's calculated or how they calculate what the trust pays in attorney fees, and that is based on what the economic damages are as the trust determines them.
And that's all you're going to get as far as from the economic damages. Is that correct?
No, because again, that's what they pay. what we get paid is the total amount. So whatever the total amount of the award is, which will include everything, we get paid a third of that amount.
But the total award, is it just our total award? Because the total award you said includes the attorney fees.
Right. It includes the portion of the attorney fees that the trust has to pay. So whatever the total amount of the award is, that's how our fees are determined. It's a third of that amount.
Okay, so then I think that we need to define award, because then the award is basically our economic plus non-economic damages. That's the award. Is that how you define award?
No, the award is the total amount that the trust determines is the right amount for your case. So whatever that amount is, if it's $1 million, $1.5 million, if it's 100,000, whatever that amount is, we receive a third of that amount.
Yeah, Jerry, it's confusing because let's say I have a total of $1 million in claims, economic, non-economic, everything. Is the award that my million plus 333,000 that they're adding into that?
No, the award is the total amount that they award. So the trust will ultimately send an offer to you. And, again, it could be 100,000, it could be $1 million, could be 2 million, whatever it is, that amount is the ultimate amount. And then let's say it's $1 million. They'll pay 75%. So of that 75%, we would receive a third, which is 250,000.
Yeah, I think the confusing part, at least for me, and I think I'm sharing it with the person who was just speaking, is that we have a claim, but it sounds like what you were saying before was that if our claim is $1 million for everything, the PG&E is adding $333,000 to that, and that's the award. So you're not actually getting a third of our claim. You're getting the incremental amount PG&E is adding to our claim to cover the legal fees.
No, we are receiving, our fee is a third of the total amount that you receive.
But is PG&E putting in anything for legal
together.
fees? Is PG&E putting anything in for legal fees, or is it just you're getting a third of ours?
No, they're paying the attorney fees on the economic damages. So that's why if they determined your economic damages were $1 million, and by they I mean the trust would pay $1 million plus whatever the attorney fees are on that, which in our case would be a third.
Okay, so let me just sum this up so it's super clear. That we'll have a claim, let's say it's $1 million, PG&E will add the legal fees to that, of which you guys will get, but it will not reduce the amount of our claim of $1 million.
Well, using your example, if there was $1 million plus 333,000, then the total amount would be 1,333,000, and the attorney's fees would be 1/3 of that. So that would be 440,000, I think, or 430,000.
Like you're.
Go ahead.
So that's the point that I was making. You're basically getting attorney fees on top of the attorney fees that PG&E is paying.
Yeah, Jerry, it's really confusing the way you're describing it, because if we have a claim for $1 million,
I mean, that's a difference of $100,000.
No, I understand.
That's a difference of $100,000.
Yeah.
That's a difference of $110,000. So the attorney fees that PG&E is going to give you is $333,000. But in that example, when we get the offer, the attorney fees are in fact going to be $443,000. That's $110,000 more than what PG&E gave you. So in reality, you're getting attorney fees of 43%. You're not getting 33%.
I'm getting attorney fees of a third of the total amount of the award.
Yeah, right. Well, you are, but you're getting, I mean, that's like that's like compounding interest, and we're compounding all this money. And I mean, and well, I appreciate everything you've done, and I have a great deal of respect for you, but that's not exactly what I understood from the beginning. I mean, that's not a third of our award. That's, I mean, you're getting, yeah. So anyway, yeah. So
Okay.
I mean, I understand, but I kind of disagree.
Okay, I mean, look, I completely understand it, and it sounds like we should talk more about it. But yeah, I mean, the way that the fee agreement is written is that, and we try to make this clear, and I understand it's a long document, but I mean, the reason we put it in there is we say we receive a 33 and 1/3%, so 1/3 of the total amount that the client receives in settlement or verdict. And that's why we phrase it that way, because that is as clear as we can make it. And what we've said throughout this is that PG&E pays the economic attorney fees. And I mean, believe me, I understand what you're saying.
And so you're getting attorney fees on top of those. So
Well,
so now
again,
I can,
it's
now
that's not.
I can,
Go ahead.
it is,
Go ahead.
no, it really is. So I have an appreciation now why you wanted PG, or why you and other attorneys wanted PG&E to pay the attorney fees, because that increased the amount of fees you'd be getting.
Well, yeah, I mean, it increases the amount that our clients are going to receive, and it increases the amount we receive. I mean, the more money
No,
we
not
recover,
really.
yeah.
Not really. Not really.
Well, no, it does,
No,
because
it actually doesn't.
well,
It
here's
actually
the reason it
doesn't.
does. If you were to recover $1 million and PG&E were not to pay any attorney fees, and it was $1 million, then our fee would be $333,000, and you would have $667,000. If PG&E pays an additional $333,000, then our fee goes up because they've paid more money, but you receive more money. So it benefits both the attorney and the client.
Yeah. Hey. So Jerry, Sharon is right. What would be really helpful is if you came up with a couple examples and send it to us, like really simple examples, because the way you just described it, you're basically getting the 33% gross up plus about 10% of our claim. So if we have $1 million claim, you're going to take about 100,000 of that million plus the 33%. So Sharon, I think that's the example, and you're absolutely right.
Oh,
so Jerry,
and he's right. We are getting more money. And so I should, and I'm not that I'm dissatisfied. I guess that the challenging part for me is that and I've attended every solitary one of these town hall meetings, but it seems like every week there's another little tidbit that comes up. Oh yeah, and then there's this, and oh yeah, now there's this. And I mean, I know we'll never be fully compensated for our loss. I know that, and I have an appreciation for that. But it's just like you think you got it, and then all of a sudden we have the next week's town hall, and now it's like, oh really? Oh, now that, so I guess I didn't get it. Okay, so now I'm going to subtract it, and it's like, pretty soon you're taking nothing from something from nothing. So anyway, so I'm done. And Jerry, I do appreciate what you've done for us. I guess I just find it challenging that something new comes up every week,
Understood.
and you think you got it and you don't. So, okay, I'm done.
No, and I understand. And one of the reasons we do this is I want to make sure that we get you as much information as we can. So I apologize for the confusion. I think the way to think of it is the fees are 1/3 of the total amount that you receive. And if you think of it that way, which is, again, the way we tried to write it, and obviously it was confusing, and that's my fault. But that is the way that it's done. And it's not just our firm. That's the way that every firm that does it, that's what a contingency fee is. So again, I apologize for the confusion.
May I speak?
All right, thank you.
Yeah, please. Go ahead.
Jerry, this lady who just brought this up, I was at the first meeting you had done in our area, and you had explained very clearly that for the economic damages, whatever you get, you get it all. We get the fee is paid directly by the PG&E. So we get that money. You get your whole amount. Then you said on the Kelly and the
Yeah.
mental problems and all that. On that, what you get, you have to give us a third of that. But on the economic damages, it was explained to me exactly as Sharon is explaining, which was if you get $1 million, we get 333 on top of that. You don't pay that at all. If you get 500,000, we get 187, whatever it is, on top of that, and we get it separate. You do not pay us. That is paid to us directly. But you do pay us on the Kelly and the emotional damages.
Okay. That's
And
a
that
little
first
bit
meeting,
different. I
put
mean,
notes
the
down,
way that
said it
Go ahead.
twice. Yeah.
Yeah, the way that I always explain it, and the way that I try to explain it, is to use the example that I used at the beginning. There's the economic damages.
Yes.
The fees are on the economic damages are paid on top of that. Then there's the non-economic damages, and our fee is a third of that entire amount. That's when I explain it, that's the way that I explain it. It works out that they pay the majority of the fees on the economic damages. But the way that it's again, the way that it's written in the contingency fee agreement and the way that I always explain it is that way. So I understand that there's confusion, but
I clearly remember, and my notes say that, and I have to refresh and see the notes again, but it was that you get whatever is awarded to you, you get that, and we get the 33% is paid by PG&E. So,
right.
So then to us, like the other people said, if you get $1 million and they award another 333 for the legal fees, you get that 333, we get the $1 million. Then there's the economic, how much is the non-economic damage? That's 300,000, you get 100, we get 200. That's how it was explained at that first meeting by you.
Well, let's do this. I understand this is confusing. Why don't we do this? Can you look at your notes and then give me a call? We'll go through it. And I mean, here's the thing. If I told you something, I'm certainly going to stick with that. The way that I always explain it and the way that we've always done it is how I just explained it. But I mean, again, that said, if I told you something, I will absolutely honor it. So look at your notes. Let's go back and talk about it, and then we can go from there. Does that make sense?
Thank you. Yeah.
Absolutely. No problem. All right. What other questions do we have?
Gerald, let me make a comment if I can, and I'm not an attorney. I think Sharon and David's points were very good, but the system is what it is. That's how it works. This is in no way trying to say positives about you, but I am far happier having a Bolt grad represent me than having Michael Watts from Texas. And if anybody wants to follow up, read the article in The Atlantic about the Vietnamese fisherman and Michael Watts. I am much happier having you represent me.
Well, I appreciate that. No, I appreciate that. And I do want to say this is complicated, and I completely understand people's frustration. And again, just to follow up with Neelam, again, if I have said to anyone anything different, that's fine. Please contact me offline and we'll go through and I'll honor that. But again, I generally do the same thing, and I generally explain it the same way.
And you know
So
what I'll do? I'll
yeah,
check with my friend who was there also in case I misheard. I
please,
want to,
yeah,
yeah.
and no problem at all. Like I said, I
It
know
was
it.
a
Go ahead.
bad
I'm sorry.
time, you know, it was a bad time, and
Yeah.
it could be that we misheard. But I'll check it and check with her
But-
also.
And
Jerry,
please
Jerry,
do, and that
you-
goes for everyone. Again, if I have said something, I will absolutely stand by it. So just check it and let me know if anybody has a different recollection.
Yeah, Jerry,
yeah, go
Jerry,
ahead.
you guys have done a phenomenal job. You guys are total pros. Interaction we've had with you has been fantastic. It's just
Thank
could like pen out an example, a really simple example. That'd be cool.
Sure, absolutely.
I don't think anyone can hear me.
Well,
No, I can hear you.
second that. I second that. And
Okay.
everybody else, Jerry was, I'd met him, but then he was working through the office here in Ukiah of a very well-known attorney who I've known for years and years. And I talked to him before I'd signed up, and he assured
Well,
me
thank
that he said, you know what, he comes very highly recommended, go for it. So,
Well, thank you. I appreciate it.
so that's in the legal community, he has a good reputation. So.
Well, thank you. I
Jerry,
appreciate that.
Jerry, I
So
have a
what-
question.
Yes, please go ahead.
Completely aside from what you guys are
Yeah.
talking about compensation or not, it seems like this PG&E lawsuit, it's so big that it's not just the Tubbs fire, but it's all Paradise. There's a lot of fires involved in this compensation process and whatnot. And I wanted to make sure that I knew who to go to in case that I needed to have personal questions or my individual case questions, and not just go to you directly, or is it you the main path? Do you have like an email that you can send out with for Tubbs fire sent to this person? I don't know how you're organizing that.
Sure. We have, depending upon where you are, the Santa Rosa office is usually the most responsive. So usually I would send requests from Tubbs clients either to Santa Rosa or Sacramento because our teams are there. The thing is, though, a lot of times someone talks with one of our team members and develops a rapport. So if you have that and you want to keep speaking to the same person, I don't want to interfere with that. On the other hand, if you just have general questions, then what I can do is put you in touch with our chief paralegal in Sacramento, and she can respond to those. Does that make sense?
Yes, thank you.
Okay, yeah, just please send me an email and I'll forward you her information. Okay. All right, who's next? All right, going once.
I have somebody just submitted something here on the chat, Jerry.
Sure.
It says, what kind of supporting evidence would be required for emotional distress and other non-economic claim aspects?
Yeah, so for emotional distress, what we're going to do is to provide a narrative. And there's just not a lot of by necessity, there's not a lot of, or by definition, there's not a lot of supporting documents we can provide. Some people do take video as they're leaving. Obviously, if you did that, we can put that in. But for the most part, it's just a matter of going through and documenting what it was that each person went through. Because while there's a lot of commonality, there's also a lot of things that are unique, and everybody was affected in a different way. So what we do is we describe what your experience was like in terms of proximity to the fire. So if you were one of those people who were, fortunate to leave with your life, then obviously we'll describe that. If you were lucky enough to get out early, we'll describe that. And then we'll talk about how the fire has affected your life, how your life has changed. In other words, if you went from living in a comfortable, 3-bedroom home to, being in a 1-bedroom apartment with your children, anything like that, we go through and we describe the most salient points for you. And then the final thing we put in is the cherished possessions. So, the photos, the love letters, things like that, the mementos that you can't replace. We put all that in, and then if they have questions, they can ask. But typically, these experiences, while everyone is unique, again, there is a lot of commonality. So unless you are going to make a claim that is very unusual or unless you aren't somebody who, for example, lived in camp, but you had to evacuate it. And certainly there were delivery drivers, there were other people like that, there were people visiting. But if for example, you didn't live in camp, but you had to evacuate that day, if you didn't live in Paradise, but you had to evacuate as a result of the campfire, then that would be something we'd have to explain. So barring something like that, where there's an unusual circumstance, you're not going to need to provide anything.
Hi, Jerry. I would like to, I don't know if you can hear me.
Yes, yeah, I can hear you. Go ahead.
Oh, great. Okay. So you might want to just scream because I'm belaboring the attorney fees, and I appreciate that. You've been very patient with everybody, and I want to commend you on that. And I've been listening to all the callers. I'm going to just throw these figures out, and you tell me if I'm wrong. Okay. I'm sticking with $1 million. Let's say the economic award is $1 million. The attorney fees would be $333,000. And let's say the non-economic award is $100,000. So the total of the economic, the attorney fees that PG&E is paying, and the non-economic totals $1,433,000. What I heard you say is that attorneys would get 33% of that total, which would come to $472,890. However, if you take the amount separately, if you say 1 million economic, 333,000 attorney, and then take the 100,000 and take 33% of that, which is 33,000. So then you're adding the attorney fees. 333,000 plus 33,000 is 366,000, which is a much lower amount.
Right.
Where am I going wrong?
No, I think you're correct. The amount that you're, or the numbers that you're describing is correct. The problem that we have, and the reason why it's not done that way, is that it's one thing if you have an award in court. If you go into court and you have a verdict, then there's a breakdown and everything is laid out. The problem with settlements is that it doesn't done that way. What they'll do is they'll come up with an overall number. So there isn't a way to break down what the economic damages are, for example. Usually what'll happen is there'll be an initial settlement offer, but there's no, when they increase it, they don't say, okay, we're applying X amount to this, X amount to that. It's just one number. And because of that, the way that it's always been done is we have a contingency fee that is 1/3 of the total settlement amount. And when we do this, we have to make sure that the amount you receive is an amount that's acceptable to you. And so that's why we focus on the net, and we say when we're doing a settlement, here's what you're going to net. And if that's acceptable to the client, then we are done. If it's not, then we keep going. So you're absolutely right. And if the structure was different, then it might be possible to do it that way. But because it's not, and because you're just dealing with one number, the way contingency fees work is it's 1/3 of the total amount. And so that's why it's done that way. But again, the numbers that you're describing are correct.
Okay, well, that's what we have to live with. Okay, thank you.
Right. Yeah.
Thank you.
Excuse me, Jerry.
Yeah, please.
We've completed our paperwork and they've taken our narrative. How is it possible to get a copy of the narrative that is going to be submitted so that we can review it?
Oh, absolutely. Yeah, just send an email and we can get that to you.
Thank you.
All right, Chewy, do we have any other questions?
More, it looks like an email, more of a comment. It says, you know, why was the trust caught off guard? Feels like we're losing another month.
Yeah, the trust was caught off guard because under the RSA, the Restructuring Support Agreement, which is the equivalent of the settlement agreement in bankruptcy, the funding date was supposed to be August 29th. And in talking with PG&E, they had not given us any indication that it was going to be before that. The first any of us heard that it was going to be before that was the day before they funded. I mean, we'd heard talk that, you know, we might fund in July, that kind of thing, but nothing that was serious. And so all of a sudden, we get the funding. It's certainly better that they funded than that they didn't, but that's the reason. That all along, the trustee has been planning on opening this up sometime in July and making the first payments in October, and there was no way to speed it up. It would be great if we could, but I think realistically, it's not going to happen.
Thanks, Jerry. And then another email I just received is,
sure,
why is the Atlas fire not included in the list of fires?
If it's not, it's a typo. It's definitely included in the trust, the agreement, the documents. When they say it's not included, do you know, is there any indication of what document they're referring to?
Not at all, Jerry. That was the only thing that was submitted.
Okay, yeah. If anybody is in the Atlas fire and would like to see it, please just send me an email and I can point you to where it is. But there's a list of all 24 fires that are included, and one of them is the Atlas fire. If you're a victim of the Atlas fire, you're absolutely entitled to be compensated out of the trust.
Thanks, Jerry.
Sure. Do we have any other questions? All right. Well, I'm hopeful. We have our first meeting of the Trust Oversight Committee, and that'll be with the trustee next Wednesday. And so I am hopeful that we'll get some more information, and next Thursday I can give that to you. So once I have some more information, if there's, you know, an increased timeline or anything like that, I will pass it along. And I want to assure you, we are moving this along as quickly as we can. The funding is great news. That was the last piece of the puzzle. Now we just need the stock to go up, and if it does, everybody is going to be in good shape. So thank you, everyone. And again, if you have any questions, please don't hesitate to reach out.
Jerry,
yeah.
Do you mind answering one more last-minute submission here?
Yeah, please.
It says, I mean, so you discussed economic and non-economic and the contingency fee. What about the amount that has to be paid back to the wildfire fund?
Oh, that will be deducted. So if, for example, you receive $10,000 from the wildfire fund and you're awarded $200,000, you're only going to get $190. So it's not like you'd have to pay fees on that extra money. Again, we only get paid when you get paid. So if your amount that you received was $190 because $10,000 had been deducted, then we would only get paid attorney fees on that amount.
Thank you.
Sure thing. All right. Take care, everybody.
Can you cover the chat question I sent in?
Oh, there was one that was not answered?
Yeah, via chat.
Oh, I'm sorry. Okay.
Let me check. Okay, it says, sounds like the economic damages need to be grossed up by 50% so that the 2/3 of the total leaves the plaintiff whole. This results in the fees being 1/3 of the total and all the fees covered by PG&E.
Right, and that's the way we've always done it in the past, is that as part of the agreement, it was the amount and then 50%. The reason I can't say for sure that we're going to do it that way here is because the trust is the one that makes the decisions. And if we're dealing with PG&E, then we can say as part of our negotiations, look, here's how it's going to work. But it's up to the trust. Now, the formula that we've always used is called the Trotter formula. And what that is the economic damages, 50% for fees, and then the non-economic damages on top of that. The reason that we selected Justice Trotter as the trustee is because we liked the formula and we wanted him to use it. Now, it's ultimately up to him because he's the trustee. We're going to push him to do that, but I can't guarantee that he will. And that's why I can't say that it will automatically be grossed up 50%, although that is absolutely what we're going to push for. I think that's the way it should be done.
Thank you, Jerry.
Sure thing. Any other questions before we take off?
I believe that's it.
Okay. All right, everybody. Take care.